If you've been flagged under Section 212A, 6, C, I of the Immigration and Nationality Act, you're probably feeling overwhelmed, confused, and maybe even hopeless. This bar, based on fraud or willful misrepresentation, can feel like a permanent stain on your immigration record. And here's the hard truth: without a waiver, it is permanent. But there's good news. There are ways forward. Every year, individuals in your situation apply for and receive waivers that allow them to move past this bar and continue their immigration journey. It's not easy, but it is absolutely possible. And in this video, we're going to break down how. Let's start with what this bar actually means. Section 212A, 6, C, I applies when an immigration officer determines that you misrepresented a material fact or committed fraud in order to receive a visa or enter the United States. This could include using false documents, giving incorrect answers during an interview, or omitting key facts on a visa application. Once that determination is made, you're considered inadmissible. That means you can't receive a visa, green card, or even enter the U.S., unless you qualify for a waiver. There are two main types of waivers we'll talk about today: the 212I waiver for immigrants, and the 212D3 waiver for non-immigrants. Let's start with the 212I. The 212I waiver is for people applying for immigrant benefits, like a green card, who've been found inadmissible due to fraud or misrepresentation. To qualify, you must have a qualifying relative who is either a U.S. citizen or lawful permanent resident. Specifically, this can be your spouse or parent. Children do not count for this waiver, even if they are U.S. citizens. Most importantly, you must prove that denying you entry would result in extreme hardship to your qualifying relative. That's the heart of the waiver. What counts as extreme hardship? It's more than just sadness or inconvenience. You'll need to show that your spouse or parent would face severe consequences, such as financial collapse, serious medical problems, mental health deterioration, or danger in your home country, if you're not allowed to stay or enter the United States. Let's walk through how to file a 212I waiver. First, you must complete Form I-601, the application for waiver of grounds of inadmissibility. You can file it with your green card application or after receiving a denial based on inadmissibility. With your form, include the filing fee, which is currently $930, but always confirm the latest fee. A copy of the notice that says you are inadmissible. Proof of your relationship to your qualifying U.S. citizen or lawful permanent resident relative. And most importantly, detailed evidence of extreme hardship. This evidence should include a hardship letter from your relative describing the emotional, financial, or medical toll your absence would have. Medical records and psychological evaluations, if applicable. Letters from doctors, clergy, community members, or employers. Proof of income loss, housing instability, or any special family needs. You can also include reports about conditions in your home country, such as crime rates, political instability, or lack of medical care. Now, let's talk about strategy. This is where many applicants fail, not because their case is weak, but because it's not presented effectively. You need to be honest, specific, and thorough. Tell your story. Explain what happened. Take responsibility. Show what you've learned and why you deserve another chance. Don't say, "My wife will be sad if I leave." Say, "My wife has lupus and depends on me to drive her to weekly treatments. Without me, she will lose access to the care she needs." Use charts or summaries if needed. Present your financial and emotional case clearly and professionally. If possible, work with an immigration attorney who can help organize and strengthen your filing. Once submitted, you'll need to wait. Processing times vary, but most cases take 6 to 12 months. During that time, you may receive a request for evidence. Don't panic. It's common. Respond completely and on time. Now, what if you're not applying for a green card? What if you just want to visit the United States temporarily? That brings us to the 212D3 waiver. This waiver is for people who want to enter the U.S. on a temporary basis, such as for tourism, business, or study, but have been found inadmissible due to misrepresentation. Unlike the 212(I) waiver, this one doesn't require a qualifying relative. It also doesn't require you to prove extreme hardship. What you do need to show is that your purpose of travel is legitimate, that you're not a threat to the U.S., and that letting you in wouldn't be against public policy. The process begins at the U.S. consulate when you apply for your visa. If the consular officer finds you inadmissible, they can recommend your case for a waiver. It is then sent to the Admissibility Review Office of U.S. Customs and Border Protection. You'll likely need to wait 2 to 4 months for a decision. If approved, you'll receive your visa with a note showing that a waiver was granted. To support your case, include a personal letter explaining your purpose of travel and your background, along with supporting documents such as invitation letters, conference registrations, proof of ties to your home country, and hotel or flight reservations. This waiver is entirely discretionary. The stronger and more respectful your case, the better your chances. Let's now talk about what to do if your waiver, either 212(I) or 212(D)(3), is denied. First, read the denial letter carefully. It will tell you why your case was rejected. The reason might be weak evidence, inconsistent information, or a failure to demonstrate hardship or purpose. Use this feedback to rebuild your case. You can reapply, and many people succeed after adding more detailed documents or getting expert help. You may also be able to file a motion to reopen or reconsider, or in some cases, appeal to the Administrative Appeals Office. These options often have strict deadlines, usually within 30 days, so act quickly. Finally, don't lose hope. Denials are painful, but they are not the end. Many immigrants are denied more than once before they finally get approval. Each attempt helps you refine your case and build a stronger application. In closing, remember this. The 212(a)(6)(c)(I) bar is serious, but it does not have to define your future. With the right waiver, the right evidence, and the right mindset, you can clear this bar and reclaim your path forward. Start by gathering your documents. Get the right information. Reach out for legal support if possible. And above all, don't give up. Because in immigration, perseverance matters. And your future is worth fighting for.